Good evening, everybody. My name is Attorney Chris DeBari. Welcome to my weekly series entitled Legalese, where I explain and answer questions that you may have regarding the law and aspects of practicing personal injury law, relationship between client and attorney, as well as the dynamic of personal injury cases in general. I try to field your questions and your calls and try to give you good answers to questions that you might have. And I appreciate everyone tuning in. If you like what you hear today, please feel free to like, share, or comment below. And I certainly do appreciate your feedback and your questions. I've gotten a lot of very good questions lately, and I've had the opportunity to follow up on those questions and provide good answers and some pretty in-depth information. And hopefully that's been helpful for some of you. And like I said, I certainly do appreciate the viewing and the questions. The thing I really wanted to discuss this evening was the communication between the client and his or her attorney. Um, Communication between a lawyer and their client form the backbone of the attorney-client relationship. And it's a very, very important aspect of what goes on, a very important dynamic of what goes on between the client and the attorney. Communication is encouraged to be open and candid. And by candid, I mean honest and truthful. And there's a reason why you want to tell your lawyer the truth. First of all, a lawyer can effectively represent you when he is in command of the facts. So hiding truths or telling half-truths to your attorney doesn't help you, it doesn't help your case, and certainly doesn't help your lawyer prepare your case. In fact, puts him at a disadvantage. When you arm your attorney with half the facts, it would be as if you were a boxer going into the ring with your right hand tied behind your back, or even worse, both hands tied behind your back, and you lead with your chin. And that's something you don't want to do. Good communication can make or break a case, and certainly make or break a relationship between an attorney and his client. Now, as I stated, the communication that goes on between an attorney and a client is strictly confidential. It's privileged information. In fact, there is a attorney-client privilege that exists in Florida, and that attorney-client privilege means that anytime you communicate with an attorney for the purpose of seeking legal counsel, or if it's your attorney in a particular case, that nothing that you and the attorney say to each other can be divulged to any third party, not to opposing counsel, not to the court, not to the police, not anyone. And that's one of the most powerful privileges we have in American law. And the attorney-client privilege is very, very important, and it stands as a cornerstone in representing clients and representing them effectively. But sometimes people don't take advantage of communicating with their attorneys for whatever reasons that they may have. Now, some of the time, as an attorney dealing in a personal injury matter in particular, or a criminal defense matter, or a contract matter, whatever it is, for most people, those are new situations to be involved in, and unfortunate situations. If you've been injured in a car accident, or your family, your loved one has been injured, it's not really the kind of place you expected to find yourself or wanted to find yourself. And there's a lot of uncertainty and a lot of information that you're going to need. Well, your attorney is going to be that source of information 100% of the time. Your attorney is skilled in civil procedure and in criminal procedure, will often know and be helpful in explaining to you the processes involved, and can often predict, not perfectly, but obviously we do have a skill set we've honed over the course of years and decades to predict what is going to happen next in a case. Provide you with here's what's coming, here's what you need to do to prepare yourself, and that's something that we're particularly good at. The example would be if we were all going to go skiing, and you are new to skiing, so you find the bunny slope to be challenging, whereas your attorney is an expert and he will ace the bunny slope without any real trouble. And the nice thing is he's also willing to give you the tips and the pointers that you need so that you can apply them to your own skiing, so that you can then master the bunny hill before moving on to more difficult terrain. And that's sort of where we find ourselves a lot of the time in these cases, where there's a lot of complicated legal stuff going on. Um, and communication and clear communication and frequent communication are extremely important things to have going on. And, there needs to be an effective method of communication too. Um, because when you think about it, it's your claim, it's your time and your money. And your attorney has an obligation to communicate with you at regular intervals concerning the status of your case. But don't leave it at that. If you have questions for your attorney on any given day, not every day, but if you have questions about things that are concerning you about your case or about any of the implications of any aspect of your case, call your lawyer up. I have it set up in my firm where I field my clients' calls and I answer the questions personally most all the time. I mean, I have my case managers, and they will occasionally be available to help the clients, but I like to take it on myself to provide the information because then it's coming from one source and probably the most educated source on the law to give that information. But one of the things that's very important, particularly the outset of the case, is you want to establish with your attorney the best method of communication. Decide what your preferences are. You like to speak over the telephone. Some communicate more effectively through email, or some prefer in-person meetings. I know that's become a little bit difficult nowadays, but my office is open, and as long as you wear a mask and I wear a mask, we can communicate. And if you insist upon a face-to-face meeting, it's not completely face-to-face, but it's there, and it's not a bad idea. So you want to discuss with your attorney what method is preferable for communication. And This is very important. I mean, and a lot of what goes on in our cases are sort of time sensitive things. So if an attorney makes an attempt to contact you, the client, about an important matter, please be prompt in your response to the attorney's inquiry because, like I said, a lot of the information that comes through is time sensitive, and we need to be able to get into communication with you, the client. So make sure that there's always a reliable source of communication and an alternative means of getting in touch with you in the event we can't reach you directly. Um, we've been given so many new tools, particularly with COVID, Zoom, and the online platforms to meet with people. But of course, there's the good old cell phone, there's FaceTime, there's texting, and there's email. So there are plenty of ways to respond to your attorney when they make a request for information. Now, one of the interesting things, too, and I talk to clients about this, some people have been involved in personal injury cases either like to or need to keep a journal of their experience on sometimes a day-to-day basis or a weekly basis, just to describe their experience, to get it down on paper, to make sure that it isn't lost for all time, just preserving the memories. Technology has made this easier. You can take notes on your phone, and you can do all of these things. And an important thing to remember about doing this is you should always address any of these diaries or communications to your attorney. So it would be, in this particular case, Dear Mr. DeBari, April 1st, 2020, woke up with a bad back, woke up with neck pain, maybe a 7 out of 10. And if you were to address it to the attorney, each of these entries, or the diary itself, if you're keeping an actual physical diary, then they would become protected communications between myself and you, the client, and the other side would not be able to discover them if we were not in a position where we wanted to turn them over. So it's very, very important, if you keep a calendar, to do it clearly and to address it to your attorney. And I said before that I like to take advantage of the opportunity to talk to the clients myself personally, but I'm not perfect and I'm not available 100% of the time. So do speak to the case managers when necessary. But I wouldn't allow a case manager necessarily to become your sole source or your primary source of information. You have the right and you deserve to be able to speak to your lawyer. And if you make that clear to the attorney, your attorney has to respect that and has to communicate with you in a reasonable manner in accordance with your wishes. So if the attorney's unavailable, sure, talk to staff, but always at least ask to speak to the lawyer and then decide whether you want to or not. If the lawyer's not available, wait for the attorney to get back to you, or if you want to ask the case manager, maybe answer an easy question. And remember, it's also important to communicate with your attorney if you receive notices in the mail of court dates, because we receive the notices, you receive the notices. I may get it first, you may get it first. So I'll make you a deal. I'll get it first. I'll call you and tell you about it. You get it first. You call me, tell me about it, take a picture of it, send it to me or whatever. So as long as we have an understanding and we can coordinate our efforts to make sure that we are present and responsible at our court dates. Also, give a little bit of response time too if you make an inquiry to the attorney. I give my clients my cell phone. Usually, my clients can reach me at any time, unless I'm in court or in a deposition or mediation, or if I'm on the other line. But I'm very good about getting back to clients quickly. But for the most part, I just answer their calls. Of course, there's a downside to that too. You end up answering the calls of pretty much everybody, including the salesmen that call you, but you make short work of those calls. And also think about it too. You may have questions you want to ask the attorney that may not be so pressing, but take advantage of the early mornings or the weekends or evenings to call the attorney, because there may be a time to be able to reach him directly, particularly me, where I use my own cell. You should be able to reach me at those times. So you generally want to call before or after business hours, or call and arrange a time where we can sit down and have a discussion, make an appointment. And like I said, you want to set these expectations with your attorney early on in the case. Say what you expect. And as an attorney, and I've been practicing law for 20 years now, a little more, I can honestly say that the times that I regret the most, where I've been the least effective, is when I have ignored my tendency to want to communicate with my clients. For me, it's a natural thing to do. I like talking to people. It's one of the reasons why I make myself accessible to the clients. And I have ignored my instincts. If I meet a client that I think is pretty self-assured and independent and really doesn't need a lot of communication, as soon as I tell myself that, I tell myself, no. Got to continue, got to communicate. Even sometimes if it seems annoying. I would rather annoy my clients with communication and information than leave them upset that I haven't. And I've learned this lesson a couple of times in practice, where I have gone against my own instincts and haven't communicated to the extent I normally would with the client, just based upon their own personality and apparent preferences, only to realize that my expectation was incorrect. And at times I've gotten the letters from the other law firm saying I no longer represent this client. So obviously you want to prevent something like that from happening. It happens to every personal injury attorney a couple of times in the course of their career, but there's not much you can do about it. But attorney-client communication is extremely important. The attorney-client privilege binds the communication. Openness and candidness, or candor, is encouraged and really necessary so that the attorney can best prepare your case, best investigate your case, and be aware of all the pertinent information before proceeding headlong into litigating a case. But anyway, that's my presentation for this evening, a little shorter than usual. But communication is a very, very important thing, and I would encourage all my clients to contact me if they have questions about their cases at any juncture that they feel they need to. And I would hope other attorneys would do that. And that's sort of the advantage I have as a small practitioner, as opposed to the big silk stocking big firms where they have to feed this big monster. They can't have their lawyers talk to you. Their lawyers are busy doing other things, and they don't really communicate with the clients until the day of their deposition or the day of their mediation. And I've spoken to enough of my new clients that I've acquired from bigger firms to know that clients do want to be communicated with, and they do prefer to have an attorney do that under most circumstances. But anyway, I hope that that's useful information. That's just sort of an admonition from me. And I appreciate you tuning in. And remember to like, share, or comment on anything below. And I hope you enjoy your evening. Please, everybody, be safe. Thank you very much.